Good morning.
Good morning.
Thank you, Mr. Tomlinson. We have read widely, and so you can assume that we have the basics on board.
I'm most grateful. I appear for the appellant along with Mr. Hamer, and Mr. Patel appears as an advocate to the court. As the court will know, this is an application, this is an appeal against in an action for harassment and misuse of private information. The case was settled on the acceptance by the defendant of the claimant's Part 36 offer. That involved giving certain undertakings, and 3 of those undertakings Mr. Justice Nicklin refused to accept. The court will have seen those undertakings, and I won't repeat them now. But the judge, although taking the view that the appeal had no realistic prospect of success, gave permission on the basis that the case raised practical issues of importance concerning undertakings to the court. And I'm sure the court is aware of this, but it's the question of exactly how undertakings are framed in harassment cases is actually a practical issue, particularly when judges like Mr. Justice Nicklin are very keen to ensure that things are done in a proper way. So there's certainly, in my experience, a dispute as to whether certain undertakings are acceptable or not. And I think the judge took the view, and we would respectfully agree that it would be helpful for this court to give guidance if it thought it was appropriate. And as the court knows, the judge indicated that he thought it might be appropriate for an advocate of the court to be instructed, and indeed that was what took place.
And we're very grateful to Mr. Patel. Thank you.
I'm not going to, in the light of your ladyship's indications, I'm not going to say much about the background, but the court will have seen and perhaps had the opportunity to read the very full particulars of claim, if I can put it that way, that were issued in this case, which was a harassment case of a really at the top end of the scale of seriousness, involving seriously offensive and deeply distressing behaviour by the defendant, who was a former colleague of the claimant, the claimant having made a complaint of rape. It was an anonymous campaign, and the defendant was only identified as the result of a Norwich pharmacal. Originally, a defence was served denying responsibility, but as I've said, eventually Part 36 offer was accepted, including the undertakings and payment of £49,000 in damages and £74,000 in costs. Much of the law is uncontroversial, as perhaps might be expected. Can I begin by just reminding the court, I'm sure the court is aware of it, but of what Mr. Justice Nicklin says in his judgment at paragraph 14, which is where he sets out the relevant, what he describes as the relevant principles. And those are, I apprehend, uncontroversial, but there's perhaps 2 points that need to be emphasised. And although one finds reference to this in the judgment, we say that the judge didn't properly take these points on board. The first is that when the court is asked to make a consent order, including the acceptance of undertakings, it should do so unless the order is in, or Justice Staunton's words, which are perhaps sound slightly dated, illegal, immoral, or so equivocal as to give rise to further dispute. That's the case of Bruce and Worthing Borough Council. I don't think it's, unless the court wishes it, necessary to turn it up. He begins his judgment with those words, and they've been repeated in subsequent cases. And that's one of the cases that is referred to in Mr. Justice Nicklin's summary of the law at
if you'll forgive me, I would like to have a very quick look at that.
Yes, it's at tab 5 of the authorities bundle.
Yes.
It was a possession action which had been compromised on the basis of a. Does your lordship have the?
Yes, I have the case. So
it was a possession action which had been compromised, and then subsequently the claimant sought to judicially review the compromise agreement on the grounds there's no power to make it. It's at page. The pagination is slightly odd because this wasn't originally the bundle of authorities. It's 59A at the bottom or 228 at the top.
Yes, well, I got 259As, which doesn't help either. But there we go. I've got it now. Thank you.
228. It's the beginning of the judgment of Lord Justice Staunton, and the passage contains those words that I mentioned to the court.
Not part of the ratio, because, as he explains in that very paragraph, because it was a case of an inquisitorial system.
It's not part of the ratio, but it's a statement which has been repeated in subsequent authorities and has not been doubted. And I'll come on to the approach that the court takes to settlement agreements. But can I just mention, because it's a case of some passing interest, and it's also one of the few cases where these issues have been ventilated, the case of Wilson and Whitworth. This is at the authorities tab 3. Wilson, Whitworth and Express and Independent newspapers. It's a curious case which was originally before this court in 1936, and the Mr. Denning, the then junior counsel for the claimant, sought to put a consent order before the court, including undertakings, and Lord Wright, the then master of the rolls, didn't like the look of it at all, and the matter then came back. Just to make the story clear, the Court of Appeal refused to accept the undertakings. It came back again before the court with in terms of a Tomlin order, and then more than 30 years later, an attempt was made to convert the Tomlin order into an injunction in the usual way. Rather curiously, the map which had been attached to the Tomlin order had been lost due to enemy action, and nobody could quite. There was some dispute as to what it contained. But the point that Mr. Justice Plowman relied on in his judgment, someone had fortuitously got hold of the transcript of the argument before the Court of Appeal in 1936, and one finds the extracts from that at page 31 of the bundle, 201 of the report, and at the bottom of the page at letter H, Lord Wright says complains that the undertaking is so vague as to be very embarrassing to the court. The undertaking, perhaps I should have referred to it as at letter E. The plaintiffs undertake within the common area of circulation. They will not, in their newspapers, advertisements, signs, content, bills, circulars, or other matter, use the word express with any greater prominence or drop the word Stratford to any further extent than the commencement of this action. And one sees the extreme difficulty of working out how one could possibly enforce such such an undertaking. And Lord Wright raised the point with Mr. Denning, and I won't read it all out, but the transcript is set out over the page. Lord Justice Romer also intervened, and then what happened was they went away and came up with a Tomlin order, which then didn't need the court to agree its terms. The point I really make in relation to that case is it shows that obviously the court will, in an appropriate case, I don't think this is controversial, the court will, if an undertaking is not clear and not going to be clearly enforceable, will refuse to accept it. But one sees from really how obvious and extreme that case was, that really it was a undertaking which appeared to make no sense at all without all kinds of additional material that wasn't there. But the important...
So, Mr. Tomlinson, sorry to interrupt, you accept that even if something has been agreed, the court is able to conclude that this is something which is not sufficiently clear and not going to be enforceable and therefore can refuse to accept?
My lady, absolutely. So if it lacks sufficient certainty, that the phrase that's been used is lacks sufficient certainty to be enforced, then the court can refuse to accept it. Must be right and think uncontroversial, was uncontroversial below.
So that's one limit on the jurisdiction.
And this was all dealt with, sorry, it was all dealt with in Wilson on the footing that the parties were inviting the court to accept undertakings to the court.
Yes, it was.
There seems to have been some debate about
there seems to be
whether
some...
it was just a contract scheduled into a Tomlin order.
Yes, Mr. Denning seems to have thought it was a Tomlin order, and Lord Wright seems to have thought it was an undertaking, but
anyway,
it was
the basis
dealt with...
for the decision to reject it was that
exactly so.
An offer of an undertaking to the court.
Yes, and exactly the same way as if the parties had formulated a consent, an injunction, or that was insufficiently certain, and the court could refuse to make it. As I say, that's uncontroversial.
So that's one limit. But as I understand it, you wouldn't dispute that there are other limits to what the parties can do. For example, if they enter into a contract which was plainly and unarguably in breach of Article 10.
No, that's not a limitation. I'll come to that exact point now, if I may.
Right, certainly.
Because really the most important case in this area is the decision of this court in 2017 in Mionis and Democratic Press.
We'll look at that in just a second, but I've just realised that in asking the question I have, I've probably diverted you from your course, because my note reminds me that you said there were 2 points to be emphasised, and I believe you so far made one.
Yes,
of which was the point about that you took from Bruce and Worthington. So I should allow you to make point 2 before we get on to Mionis.
My Lord, on the contrary, Mionis embodies my point 2. This is my second point, which is the importance of giving effect to what the parties have agreed. And the Mionis, I don't know if the court is familiar with the terms, but put simply, this was a settlement of a libel action where the defendant had entered into an agreement which is to be set out, the terms of which are set out at page 201F or 31 of the...
I'm sorry, I'm not at the right divider.
16. No, I'm so sorry.
It's 16, I've got it.
Let me start again. Wrong note. Authority 16 is Mionis, and the terms are set out at page... So the paragraph 26 of the judgment of this court.
The dispute was about clause 3.2.
The dispute was about clause 3.2, which involved an undertaking not to publish any articles or statements in any form which refer to the claimant or their immediate family, and so on. And Mr. Justice Eadie, I think Sir David Eadie at that stage, said that the held, and it was not disputed, that included indirect reference as well as direct reference. So it was very wide in terms, and a plain and obvious fetter on the Article 10 rights of the defendant. The argument in this court focused on the Article 10 question, and again put shortly, not directly relevant to this case. The court held that the entering into of the settlement was a waiver of the Article 10 rights, and a party was entitled to agree to waive their Article 10 rights, and that's what had happened in this case. But what the point I want to emphasise, and is highly relevant in this case, is what this court has to say about settlement, and beginning at paragraph 87, internal page 689, electronic 344, and referring to the decision in Warren and Random House. However settlement is reached, there were powerful and common underlying reasons it might to uphold such a bargain, save in exceptional circumstances. And we rely on that statement of the position. There's then, from paragraph 88 through to 92, a summary of the position in relation to settlement, quoting Lord Bingham on a passage beginning, "The law loves a compromise," and really making the point that, save in exceptional circumstances, the court should uphold the bargain that the parties have reached. And we say that that's a highly relevant consideration, which Mr. Justice Nicklin failed to properly to take into account in this case. Of course, there are restrictions. I mean, my Lord Justice Arnold refers to Article 10. There are
Well, specifically in relation to meonis, what I had in mind was paragraph 103. So, in the last sentence of paragraph 103, Lady Justice Sharp, as she there was, says, the issue thus resolves itself into one of proportionality, and in particular, whether the restrictions in clause 3.2 are a disproportionate interference with the defendant's Article 10 rights. So, the law, as I understand it to be stated here, and tell me if you are submitting to the contrary, is that a contractual agreement is a powerful and weighty factor for the court to take into account, but it is not determinative. The court retains its duty to decide whether it goes too far in restricting a party's Article 10 rights because it's disproportionate. And if it does go too far, the court not only may, but must decline to enforce it.
My Lord, I would
you dissent from that analysis?
I would accept that statement, save to make this crucial additional point, that in assessing proportionality, the court doesn't come to the exercise, as it were, de novo, the court, one of the crucial factor in assessing proportionality is the fact that one party has agreed that their rights be waived. So
absolutely, to be sure, that's made clear, as is also the consideration you mentioned a moment ago, which is it's not merely a contractual agreement, which is a powerful factor in its own right, but also, over and above that, it's in a settlement of litigation. And of course, there's a powerful public interest, as is made clear in this judgment, in supporting settlement agreements. So those are two powerful considerations in favour of enforcing the agreement. It doesn't mean to say that you can enforce a contract that says the sun is going to rise tomorrow.
there are
The prohibits one from saying that, to be clear.
the compelling one to say it. But the, my Lord, yes, I agree that at the limit, and exceptional circumstances is the word, is the phrase that I'd refer to that Lady Justice Sharp uses at paragraph 87. The court is not deprived of jurisdiction by the agreement of the parties, but it's a very powerful factor, and the court would really have to have very good reasons for going behind it. And I'll come on to this if I may in a moment, because some of the examples given by Mr. Justice Nicklin, if the parties agreed completely absurd things like not eating bananas ever again, or singing the Marseillaise in Trafalgar Square, then the court can say that the court is not going to get involved. The court, these are undertakings the court is not prepared to accept. You know, if someone gave an undertaking never to use the future tense in their speech ever again, or something completely absurd, then the court would say no, we're not going to accept that undertaking.
And there are two elements to that, aren't there? First of all, the frivolous and the absurd, but also the fact that it's relatively unlikely that those limitations have anything to do with the remedy sought or the harm that's allegedly been suffered. And the court isn't going to accept undertakings unless there is some correlation between the two.
Well, Melody, I'll deal with that point now if your ladyship wishes
No, I don't
me
want
to,
to
but
take you off your horse, that's
I was
fine.
proposing to deal with that very point a little later.
Fine.
Because that's a point that's made by a friend, and one that we say actually isn't right. It's not in accordance with the practice of the courts.
Well, if I'm going to be pulled up on that, Mr. Tomlinson, I would then say that it has to have something to do with the harm that's suffered, protection from a harm in the quadrilla sense. But we'll come and discuss that later.
My lady, well, it's in your ladyship's mind and in mine. I would make this point that it's relatively common in practice when litigation involves allegations of harm by the claimant against the defendant, for other issues to come into play, and for the defendant to say, well, the claimant's been behaving badly in these ways as well, and that may come in disclosure and so on, and then for the action to be settled on
a clearing up basis.
On a clearing up basis, where the parties give mutual undertakings. I mean, there's actually a precedent in Atkins court forms for just such a set of undertakings. So where the undertakings given by the defendant may have nothing whatever to do with the complaint made by the claimant, that they just arise out of some collateral dealing that they've had, and that everybody says, let's sort everything out and give the undertaking. So,
well, let's leave it at frivolous then.
Yes, you can't. So to say, I would say that, and this is a point made by the advocates of the court with which we disagree, you can't say the court can't accept undertakings if they're not in some way connected to the subject matter of the action, because that's just not what happens in practice. As I say, mutual undertakings are very often given.
Can I raise a different point arising from paragraph 103 in the context of 102 of my owners? The way I read this was that Lady Justice Sharp was placing weight on the importance of freedom of expression by a democratic press organisation, which was the defendant in that case, not out of paternalistic concern for the individual rights of that party, so much as out of concern for the wider interests of the public at large in receiving information on matters of public interest, which would be consistent with the Neville case in 1915.
Yes.
All of which makes complete sense in the context of a professional news organisation, but has perhaps less weight in the more day-to-day experience of harassment by one individual or another.
Well, my Lord, I'd agree. I didn't go into that with my Lord Justice Arnold, but obviously one of the exceptional circumstances is if you're dealing with a news organisation that's dealing with matters of importance to the public, it may be that the court will say, as in the Neville case, or whatever the news organisation is prepared to agree, we think that will be damaging to the interests of the public more generally, and their Article 10.
Yes, because obviously in Neville we were a long time before the Convention, let alone the Human Rights Act, but the court found a legal basis for not enforcing the contract to what they saw as a bribe to shut up about the...
Yes, and of course that's distinguished in Meonis, and the Lady Justice Sharp takes the view that really something else was going on in Neville, which was effectively a dubious businessman was bribing a newspaper not to report on his dubious activity.
Yes, well, that having read the judgment, it's pretty clear that that's what the Court of Appeals and Mr. Justice Atkin
had in mind.
Thought of the matter.
So can I just refer to one other passage in Meonis while I'm there, because it's we say highly relevant to the judge's reasoning in this case, and that's the conclusion at paragraph 105, where she deals with the certainty question, and the arguments that had been addressed about the difficulty of enforcement of clause 3.2, and obviously that was a consideration in the mind of Mr. Justice Nicklin in this case. And she dismisses those considerations, saying this is all well understood. And then this important sentence: tangential or remote indirect reference to the claimant and his family are unlikely to result in an application to commit or one with even a remote chance of success. So she's taking what we say is an entirely sensible, practical and pragmatic view. The fact that you can imagine circumstances in which a ridiculous application to commit might be made is of itself not a reason for not accepting the undertaking. I'll return to that because it is part of the judge's reasoning in this case. So with those slight expansions of the position, I say that where a case is settled by agreement and the agreement involves undertakings to the court, those should be accepted, provided that they're legal, not contrary to public policy, and sufficiently certain. The advocates of the court have suggested two further potential limitations to the court's jurisdiction to accept undertakings. And I'll address those if I may, because obviously it's important for the court to have the full picture before it and the full area of dispute argued if there is an area of dispute. In her skeleton, on 3 occasions, she, when considering the what the court should do in relation to acceptance of undertakings and so on, if perhaps I can just take the summary from 4.1 on page 2 of her skeleton. I apprehend it's not in the bundle and it's separate. She adds these words to the words I've already mentioned about certainty, illegality, and so on. If they do not strike an appropriate and proportionate balance between the need to avoid too wide a restraint and provide an effective remedy. And I say that those aren't, that restriction, it is not, that formulation is not supported by the authorities. It's true that there are some cases in which the court has refused to grant an injunction on the basis it would be pointless. But there's a discussion, and perhaps it's just worth turning it up in D and P, tab 14 of the authorities bundle. That was a case about a post-termination covenants in an employment. And paragraph 16 to 21, Sir Colin Rymer discusses a very well-known dictum of Lord Cairns in Doherty and Allen, where in relation to injunctions and negative covenants, and really goes on to say this, that there may be, although in general the court will always enforce negative covenants by injunction, that there may be cases effectively where it's pointless and the court won't do it. And I won't read out the passage through to 16 through to 21, but he gives an example suggested by counsel at the end of paragraph 21, a simple example where there's a covenant to protect confidential information, and the information is already in the public domain, even if there's a not confidential anymore, even if there's a negative covenant. It's pointless to grant an injunction to restrain something which it involves no wrong. But those are limit cases, and if one, Ms. Patel refers to the discussion in Snell, which is at tab 27 of the authorities bundle. And Snell discusses, it's under the subheading at page 551, paragraph 18036, the discretion to refuse relief. Deals with the various well-known headings, such as specific performance by the back door, order ineffective, inequitable conduct by the claimant, hardship, late fees, and so on. And then this last one, public interest. And there are certain circumstances in which the court won't grant an injunction, or accept an undertaking for reasons of public interest. Where private rights have to give way to more extensive public rights, or important public rights. And really, what that discussion, there's a reference to the, shall I put it this way, the controversial case of Miller and Jackson involving Lord Denning and cricket, the court may recollect, where Lord Denning seemed to think that the rights of people playing cricket should take precedence over the rights of people not to have a nuisance committed. A case which has not commanded universal assent. But
now we have to read in the light of the Supreme Court's recent decision in the Tate case.
Indeed. But the examples that are given show really how extreme, how limited this jurisdiction is, and the examples where we're talking about jets causing a nuisance, and the defence of the realm must take priority over the rights of individuals. But there's no, we say there's, obviously there are such limit cases. I wouldn't seek to disagree. And I was going to mention under this heading the point I was making in discussion with my lady earlier, that obviously cases where you're talking about triviality or where the court won't grant an injunction or accept an undertaking where there's a powerful public interest, or where it's the undertaking involves a matter of utter triviality, as the judge says at paragraph 18 in his judgment.
One analysis of the banana example is that the court would make itself look absurd.
Well,
to contemplate enforcing an injunction, an agreement of that kind.
Well, exactly, and the court is plainly has a jurisdiction to refuse to make orders of that kind, whether or not they've been agreed between the parties. But what we disagree with the advocate to the court, what we disagree with her about is that there's some general principle that must be applied in every case, that it's got to be, the order has got to strike an appropriate and proportionate balance between the need to avoid too wide a restraint and provide an effective remedy. Certainly in the case where there's a settlement agreement, where the parties have settled litigation, that is not, we say, a general requirement. The other point in which we disagree with the advocate to the court is the question of, and again I've touched on this already, is whether the court can accept an undertaking that goes outside the nexus of the litigation, or she submits that the court can't accept an undertaking that goes beyond its power to grant an injunction. Well, with respect, that's simply wrong. The court consistently accepts undertakings which go beyond its power to grant injunctions. A passage in Arnold and Edie is cited where the learned authors, perhaps it's just worth turning it up at 24 of the authorities. The learned authors say at paragraph 204, the value of the court's ability to accept enforceable undertakings in civil litigation hardly needs to be stated.
I'm sorry, I am at divider 24, and then you were taking us to
paragraph 204. It's the last page.
12,204.
12. Thank you.
Sorry, 12,204.
Thank you. Sorry.
The value of the court's ability to accept enforceable undertakings in civil litigation needs hardly to be stated. Flexibility ought to be especially useful in family proceedings and so on.
Well, it's really the last penultimate sentence you want, isn't it? The court is not confined to accepting undertakings in terms which it has the power to propose without consent by way of injunction.
Yes. And referring to undertakings to undergo medical and psychiatric treatment that one sometimes finds on committal applications. What's suggested by the advocates at the court is that that's confined to the contempt jurisdiction. But again, we say there's no warrant for it. It's a very useful and flexible jurisdiction, and the court may think it, and I'm sure the members of the court have had experience of this. There are situations in which it's of great value if one party or other to proceedings undertakes to do something or not to do something, which is not strictly speaking within the court's powers, but really helps advance matters. the judge himself recognised that parties can settle litigation on terms which go beyond what could be ordered by way of relief. And Mionis is a very good example. It was included in a settlement agreement in a Tomlin order, which the court then converted into an injunction. And it follows from the reasoning in that case that the court would have accepted undertakings in the same form. Because after all, as it were, the stage of the Tomlin order is a procedural matter rather than a matter of jurisdiction. I've already really addressed the question of the nexus point. That again, we say that that's just contrary to the day-to-day practice of the courts. The courts take a perfectly sensible, pragmatic view that if there are proper undertakings to be given, which bring the litigation to an end or advance matters or protect rights of people, those undertakings should be accepted. There can't be any rule saying, no, this would be a useful undertaking for the party to make, but I'm not going to accept it because it doesn't have a nexus with the matters in issue in the litigation. Certainly nothing that appears anywhere in the case law, certainly in this jurisdiction. There's no case in which it said, I'm sorry, an undertaking can't be accepted for that kind of reason. As I say, it's actually quite common for cross undertakings to be given to settle litigation where the undertakings from the defendant have no nexus at all with the matter in primary dispute. So, my lady and my lords, we say that the overall position, and this really is our first ground of appeal, that the judge should have proceeded on the basis that provided the undertakings in this case were not illegal, contrary to public policy, sufficiently certain, he should have accepted them. And I'll come on to in a moment to the question of certainty. But in reality, the judge doesn't say that it doesn't take the view that the undertakings are uncertain. He takes the view that there may be some limit cases in which there could be silly complaints of breach, which is something which can happen in any case. Because if one just thinks for a moment about an undertaking or an injunction to prevent a trespass to land, obviously that would be breached if someone put their big toe across the line. But no sensible person would bring an application to commit in such a case. And if they did, they would get short shrift from the court. So we say that really on the basis of the proper principled approach to undertakings offered in settlement of litigation, the judge should have accepted these undertakings. But the judge says something about them being broad/vague, which itself is a bit problematic because a broad undertaking is a different creature from a vague undertaking. A broad undertaking is one, I suppose, which takes in too much, and a vague undertaking is one that's not clear what it takes in. We point out in our skeleton that in terms of breadth, actually these undertakings in this kind of form are regularly accepted by the courts. And nobody's suggested that they give rise to any particular difficulty. We refer to 3 cases, and it's perhaps just...
Yes, can you just give me a route map of where you're going from here? Because I don't want to divert you from your submissions as to the general approach, if you finish with those. But when we get onto the specifics of the particular undertakings, could you give me a heads up, as it were, because I have a specific question about undertaking number 1.
Yes,
I don't want to interrupt your flow.
I am very kind.
But may I do so before, but if you're going on to the specifics, and my Lord Justice Arnold has an issue in relation to undertaking 1, could I just interject before we go on to say, and you don't say that there's anything specific or unusual that arises because this was the acceptance of a Part 36 offer?
I don't.
Rather than any other kind of settlement. I just wanted to make sure of that.
Melody, I don't.
Thank you.
And I remind your ladyship of the passage in Meonis where with reference to Warren, Lady Justice Sharp, Warren was a case about an offer of amends, but she effectively says the same approach applies whether this is a contractual or a statutory settlement and so on. I mean, Part 36 is a curious creature which has all kinds of strange, potentially strange features, and as we know, a Part 36 offer can be accepted even though not certain in its terms. But before being put in the form of a court order, certainty must result, otherwise it would fall foul of the...
That's fine. Thank you. So you're going on
I'm now
to the breadth point.
I'm now going on to deal with the specific undertakings themselves.
Mm-hmm.
And what we said is that these undertakings are perfectly clear. They're of a type which is regularly made accepted by courts or dealt with in terms of injunctions. And what's perhaps particularly important in this case is that what they're directed at is the actual campaign of harassment. Mrs. Justice Collins Wright in the Dew and Mills Nannin case, which I'll come to now, describes the undertakings in that case as being designed to stop the things constituting the campaign. And these were the things constituting the campaign.
That's an interesting point, and I've been sort of trying to think that one through. Because, as we know, this is a case where, through the Part 36 machinery, that in itself doesn't matter. There's been settlement of an underlying dispute. And as you rightly point out, the defendant has agreed to pay damages and costs and to give undertakings and settlement of the dispute. But am I right in understanding that, formally speaking, the defendant hasn't made any admissions?
I believe that. Yes.
What relevance, if any, do you say that has? The reason being that one of the factors that one takes into account when you've got a court decision is that certain matters will thereafter be raised judicata. Where you've got a settlement which involves admissions, then the admissions will have a similar preclusive effect on re-litigation. But what happens when you've got neither a court finding nor admissions? What then?
Well, if there's a court order, the defendant must comply with the terms of that order. It's uncontroversial here that there's a contract, and the defendant must comply with the terms of that contract. And if the defendant breached that contract, then the claimant could trigger contractual remedy.
Let me focus my question. It's probably a little too vague, and I'm sure it's my fault. Let's look at one that ultimately the judge did accept it: harassment. So, on a finding, on if there were to be an allegation or contempt of that undertaking, the court hearing the contempt application would have to decide not only whether the conduct alleged had actually taken place, but also whether it constituted harassment as a matter of law.
Yes, certainly.
And there would be no omissions or res judicata previous finding that could be relied upon by way of any form of shortcut.
My Lord, yes, I see where your Lordship's going. It's harassment is a very fact-specific tort. It depends on precisely what someone is doing in what circumstances and what may be harassing. The classic examples are if I come up to you and say good morning, that's not harassment. But if I do it 500 times a day, then you become perturbed. So to say that there's and that may well be harassment. To say that there could be a res judicata as to whether specific items of conduct constituted harassment is probably itself very difficult. I mean, if there was, if we're talking about a breach of undertaking 7, and the claimant had discovered that the defendant was impersonating her on social media. So there's no undertaking about impersonation, but there's then whether or not there was an admission that there'd been harassment in the past,
you'd have to prove it for the future.
But in relation to that particular piece of impersonation, it would have to be proved it was harassment.
Isn't that the reason in harassment cases why it's desirable to pick out specific forms of conduct which have been engaged in the past
Exactly.
and have been considered or alleged to amount to
exactly so, my Lord.
and then you've got a clear provision, undertaking, injunction, whatever it may be, the breach of which or otherwise is easily ascertained.
Well, my Lord, your Lordship is, I know, very familiar with all this, but exactly so. So what happens in practice, and perhaps, years ago, back in the late 1990s when harassment injunctions were first a thing, you might have an injunction to prevent harassment, and exactly that problem arose. So then what you would do is particularise, and Mr. Justice Nicklin makes it clear, and certainly my experience in other cases is sometimes he says, I don't think an injunction to prevent harassment is a good idea because that's uncertain. What you need is to deal with all the specific instances of what you say constitute harassment and make those part of the injunction or the undertaking.
Yes, so as I understand it, your submission is that there's a paradox in the judge's reasoning in that he's prepared to accept the general form in paragraph 7, undertaking 7, but has a problem apparently with the more specific forms in
Yes.
1 to 3.
Yes. And as my Lord Justice Warby says it's absolutely common currency that in these kind of cases where harassment often involves subterfuge, surreptitious campaigns where people are doing things designed to cause others hurt and annoyance, and finding out that they've done it is often difficult. And when you find out that they've done it, you don't want to have to, as it were, have a trial every time to find out whether that crosses the line from the unpleasant into the unreasonable, crossing the line into harassment.
And the inclusion of an undertaking such as 7 is a fallback, recognising that harassers are ingenious and may develop new
My Lord,
ways
exactly
of
so.
achieving the same objective.
And that's why we try and put those into injunctions precisely because if the previous harassment has consisted of bombarding with emails and text messages, you don't want to the person then to use WhatsApp. Say, oh well, that's not covered by the injunction. It's only text messages and emails. So it's a useful catch-all. So, my lords, my lady, what I was going to point out was that the judge's antipathy towards the 3 undertakings that he refused to accept is curious because it's inconsistent with, among other things, previous undertakings he's accepted himself. And I refer to I mentioned already the Jew and Mills-Nannin case at tab 22 of the authorities bundle. And this is an application to commit. And the case was settled on undertakings, and the paragraph 3 deals with the undertakings. It's quite a long list of things, as the point made by my lord a moment ago, because the activities comprising the course of conduct complained of were multiple. He undertook, among other things, not to communicate with Ms. Dew, her family, her friends, university, her employers, not to monitor them or impersonate them, not to publish a private and confidential information. And I'm not sure it appears in this judgment, but I don't think it's controversial. Those were undertakings accepted by Mr. Justice Nicklin at an earlier hearing. Those are effectively the same as certainly undertakings 2 and 3, impersonate and monitor. And not only was no issue raised about breadth and enforceability, but they were enforced. There was a committal here. We also refer to the case of Galloway and Ali Khan at tab 18 of the authorities a judgment of my Lord Justice Warby for, I'm not quite sure why it's formal draft judgment.
No, I mean, there are a couple of odd typos, but I seem to remember approving it. I think
well, it's not available on
systems, I definitely did see it.
On the usual services. Yeah. I'm not quite sure why.
Yeah.
Anyway, there we are. I'm simply relying on it for the undertakings, which are set out at paragraph 3. Not to publish in any way, including online, any reference, whether express or implied, to Mr. Galloway. Not to republish any statement made by any third party which referred to Mr. Galloway. And that's, in substance, the same as paragraph 1 of relevant undertaking 1. An undertaking which was given to accepted by Sir David Eady, so it appears in 2017, and then was a subject of an application to commit before my lord. And one final reference in the criminal context, and of course the court will be aware that harassment is a curious creature because it's a crime and it's a civil wrong, and the two are coterminous. This was obviously a very serious, tab 23, the Belfield case, an extremely serious course of conduct resulting in very substantial prison sentence. But among one of the orders made by Mr. Justice Saini is at paragraph 61. Prohibition on contact, which is very common in such injunctions, but you must not publish any form, publication, electronic communication, any statement, other material relating to or purporting to relate to them. You must not monitor, the use by any of the internet, email, any form of electronic communication. So again, an order is in this case an order, but a criminal order, not to monitor. And these are similar again to undertakings 1 and 3. My lady, my lords, we say that those are simply by way of examples, and really they show that there's no contrary example which shows that such undertakings have given rise to any kind of practical difficulty of the kind that the judge seems to envisage is possible. Of course, one can always think of, at the margin, of absurd examples where things can go wrong. But the fact, and this is my reference to paragraph 105 of Mionis, where Lady Justice Sharp took a practical view. It's a matter of practicality, bearing in mind the defendant has agreed to this. So he must have been satisfied after receiving legal advice that these were matters which he could, because he was obviously legally represented. He must have been satisfied that these were matters which he could comply with. They weren't going to cause him difficulties. He's promised to comply with them. They're of a type which is regularly given and accepted. And as I say, they're really moulded to the nature of the campaign. One of the objections that's raised by Mr. Justice Nicklin, a curious one, is to say well, that the first undertaking would prevent the defendant from apologising to the claimant. Well, the defendant's never given any indication that that's what he wants to do. Of course, he could, because he could communicate via lawyers. If that's there's no prohibition on communicating via lawyers, but that's not something that in practice arises at all.
No, I quite see the force of that solution. However, I have an entirely different problem with undertaking number 1, which so far nobody seems to have spotted, which I find quite surprising. And the problem is this: the claimant and the defendant are both research scientists. They both have doctorates to their name, and we know that they both work together at Fermilab, which tells you that their field is experimental physics.
They did. I think
they did work. I'm not saying they still do,
yes.
But they did. So that tells you two things. First of all, they are people who have worked in the same field of science. Moreover, more specifically, the field of science in question, as I've just said, is experimental physics. Now, that is an area in which collaboration between large numbers of scientists is commonplace. And as with all other areas of scientists publish their research in scientific journals. And it is scientific convention, which is regarded as unethical not to comply with, that you cite each other's work by reference to each other's publications. Therefore, it is inherently probable that both of these scientists will find it necessary to comply with their scientific ethical obligations to include footnotes in their respective articles to publications of which the others are named co-authors or authors. And yet undertaking 1 prevents that. Now, it's very easy to deal with this problem, because just as you have an exception for seeking legal advice, an exception for naming each other in scientific papers in journals is equally easy to insert by way of exception. But I have a real problem with it as it stands.
My lord, two things. I'll deal with the question of whether and to what extent the court should be suggesting variations under my ground 4. But we would say that that would be caught by the proviso in 1B.
No,
Not necessarily.
no, not at all.
But
Because research scientists aren't necessarily employed under any contract of employment, for starters.
Well, this is it. My second response to this is something that the defendant has agreed to, and therefore the defendant must. I've no idea, but the defendant may
Because he hasn't been properly advised. Because scientists, I'm sorry, this is a real problem of lawyers not understanding science, and scientists not appreciating the legal consequences of things that they agree to.
Well, your lordship may be right. I've no idea the level of appreciation of science of his solicitors or of his understanding of this undertaking. I would say, however, that this is an undertaking which, and this is entirely uncontroversial. He is bound as a matter of contract to this, and because he's agreed to it.
Are you seriously suggesting the court would enforce a contract to stop someone naming someone who is actually an author of a scientific publication as being the author of that scientific publication in a footnote to a scientific article?
But that would, I would say, my lord, exactly fall within the kind of exception that I've been talking about, and really along the lines of Mr. Justice Nicklin's limit examples. If the position was that, and I say I have no idea what papers these two individuals have published, whether their areas of research overlap and so on and so forth. But if there was a situation that arose of the type your lordship is contemplating, no sensible person would ever bring an application to commit, and no court would ever entertain such an application.
But you shouldn't have the chilling effect of the threat of committal proceedings. Look, in people who work at Family Lab, the papers typically have dozens and sometimes hundreds of authors.
Indeed.
I think it's a racing certainty that there are papers already published where both claimant or defendant are named co-authors amongst the dozens or hundreds. So Dr. Backhouse will be prevented from citing his own previous citations. I mean, I'm sorry, this is just completely unacceptable.
Well, my lord, I think I am entitled to take the point, and I do take it, that whatever your lordship's perfectly understandable and proper concerns, this is something that the defendant has agreed to. But can I come on to the question of variation in a few moments? If the court takes the view that this is something which is a matter of serious concern.
Well, it's easily dealt with.
Well, exactly so. So an additional proviso, and I don't want to go completely out of order because I'm going to deal with this in a moment.
And you're dealing with Mr. Justice Nicklin's concerns, and you've got to number one, and I think you're going to go on in relation to impersonation and what he says about mimicry. Yes,
and I mean that's another. Of course, it's possible that I think in the course of argument he referred to the John Bird and John Fortune sort of humorous exchanges, and perhaps that Dr. Backhouse would participate in one and imitating Dr. Smith. Well, such a thing is conceivable, but really so unlikely as to try and, you know, again, one can't formulate an injunction or an undertaking to cover every possible minute potential trivial breach and exclude that. And impersonation is a very important point because in the context of the internet, the impersonation of others is a very serious form of harassment, exactly what took place in this case. And people create there were false accounts created suggesting that the claimant was a sex worker and then attracting, by impersonating her, and then attracting repulsive messages from third parties. And the idea that it's attempting to impersonate is a very good example of the kind of situation that my Lord Justice Warby was talking about earlier. There may be some argument about whether an attempt to impersonate constitutes harassment. And if you just have undertaking 7, then that argument would potentially arise if there was a clear case where it was demonstrated that this defendant had actually impersonated the claimant again. There'd be an argument about whether that was a breach. But if one has this undertaking, then the position becomes clear.
And I'm sure you say that mimicry, in fact, is probably different from impersonation.
Mimicry may not be impersonation in any event. To say that these are too broad, as I say, it's an argument which could be deployed in relation to any, or almost any injunction. There are going to be limit cases in which you have potentially trivial breaches, and the court could take a practical view, as it did in Mionis. In relation to vagueness, it's, as I've already said, vagueness and breadth, excessive breadth, are two different things. But it's very common for the court to make orders which are with uncertain boundaries. The harassment undertaking accepted by the judge is one example. But as my Lord Justice Warby were very familiar with, it's very common for there to be undertakings or injunctions in libel cases not to publish the same or similar words defamatory of the claimant. Again, it's not clear where the boundary of that is. Or to take another example, undertakings to use best endeavours or reasonable endeavours. There may well be an argument about what those are. But there's the position in relation to these undertakings is no worse than any of those examples. So we say that they're neither too broad nor too vague. They're certainly broad in effect, and maybe too broad in Lord Justice Arnold's example, but they're not. They don't lack precision or enforceability, which is the crucial thing. They don't lack, in the words I've used already, sufficient certainty. Can I just now deal with ground 4, and this is goes back to Lord Justice Arnold's point that what we say under this head is that, of course, the court can't settle undertakings. The court, but what the court can do, and bearing in mind what's involved here is the process of giving effect to a settlement of civil proceedings. What the court can do is to point out difficulties with the if such difficulties exist, point out difficulties with the undertakings that the parties have agreed. The court can't rewrite the undertakings, but what the court can say is, well, do you want to adjourn for half an hour and you discuss whether slightly revised undertakings should be put before the court. And that indeed is what happened in the case I referred to at the beginning of my submissions, the case in 1936 where the Wilson and Whitworth, the master of the Lord Wright, the master of the rolls, sent Mr. Denning and Mr. Slade, or whoever it was, off to think about it and come back with another version. And if any of the concerns of Mr. Justice Nicklin that were valid, that's the course he should have taken. That he should have given the parties the opportunity to agree a slightly revised version, and that had he had the slightly more in-depth knowledge of scientific practice that my Lord Justice Arnold has, that may be a point that he would have spotted and then could have suggested an appropriate proviso, further proviso to undertaking 1, which, as my Lord said, would be extremely easy to formulate and would deal entirely with that objection. So, my Lady, my Lords, we say really this is an important but straightforward case, that the judge should have accepted the 3 undertakings in question, that he should have taken into account, which he didn't do. He referred to, but didn't give any proper weight to the fact that they were part of a settlement agreement. And then, on that basis, he should have taken the approach really taken by this court in the onus and accepted those undertakings. That would have been introduced clarity, because otherwise I should have made this, the court is I'm sure aware of it, but should have made this point at the outset. Otherwise the parties could come back, if there was a breach and an argument, the claimant could come back and seek to have this agreement enforced by a way of injunction, and then the argument would have arisen again. And it's the judge had perfectly proper and understandable concerns about the limited resources available to the court and so on, but it's actually a good idea to bring everything to an end on a agreed basis at the earliest possible opportunity, which is what he failed to do. So, my Lady, my Lords, unless there's anything I can assist with.
I just wanted to ask, in relation to my Lord's point about the breadth of undertaking 1 and its impact on citation of papers, is it your submission that the only way that could be accommodated is by way of the 30 minutes adjournment to see if the parties can haggle their way into another exception, or is there some other method whereby the court could say, well, we're accepting all these undertakings, but the order will provide that we're not going to enforce undertaking 1 in respect of, however it's defined, citation in the course of academic discourse, for public policy reasons, or whatever the legal analysis might be.
Indeed, or another possibility is that the claimant could offer a cross undertaking or something recorded in the order that she wouldn't regard such matters would not be treated as a breach of the order. So that
that's probably a neater way, but in the absence of such an undertaking,
and I'm sure that such an undertaking
would ultimately have choice over whether to reject undertaking 1 in its entirety because it was not so qualified, or to find a way in which it could be so qualified.
Well, there's all the whole issue about which Mr. Justice Nicklin refers to, about the court rewriting the parties' agreements, and for all we know, it seems very unlikely, but it's possible that this problem was in the contemplation of the parties when the agreement was reached and they decided it was not one that they were concerned about. But the court could certainly, the court can't rewrite the agreement, but the court, it's an interesting idea, which I don't
But
think
it's the blue pencil test, is it severable? I mean, if one part of it was an unlawful restraint of trade, it might be that other parts could be enforced.
Well, my Lord, I was thinking of a different point, I think.
Right. Sorry, I should have waited for you to make it.
No. I was thinking of a if there was a problem that the claimant could undertake, that they wouldn't enforce the undertaking in certain respects. But of course, the point suggested by your Lordship is more interesting, as whether the court could accept the undertakings, but record in the order that it regarded it would not
Court could make a declaration.
that undertaking 1 could not be enforced
Yes.
in certain respects, and that wouldn't require the agreement of the parties.
it would be to give effect to Article 10. I mean, you can put it in terms of public policy if you want to look at it in common law terms, but as a ready way forward is Article 10, which surely applies with considerable force when we're talking about academic discourse.
Yes, there's certainly a very important public benefit in academic discourse. But the court could, I mean, there are a series of mechanisms that could be employed, but we've got the practical difficulty today. If the court were minded to allow the appeal, that we don't have the defendant represented, so we don't have the defendant in a position to agree a variation of these undertakings. But we could either by a declaratory order, or I'm sure I could obtain instructions to provide the cross undertaking in the form that I've indicated, not to treat any citation of academic papers as being a breach of undertaking 1.
But in any event, Mr. Tomlinson, you're happy to accept that although the court can't rewrite the bargain, first of all, it is legitimate for the court to say, nevertheless, I have concerns about X and Y, and you either might like to think about it and come back, or alternatively to take one of these other avenues, including a declaratory avenue.
But that's never been controversial, and your ladyship will have seen from the judgment. Of course, the court has the parties can't come along to the court and say, you must do this. Whatever you think about it, the court has plainly got to examine undertakings and assess their propriety in terms of the rules I've suggested.
Thank you very much indeed. Done. Ms. Patel.
My lady, my lords, I have 5 points. They are broadly summarised in paragraph 4 of my skeleton, but slightly developed. First point is, position of principle is that in the exercise of its inherent jurisdiction, the court may refuse to accept undertakings, just as it may refuse to grant injunctions, which are insufficiently certain, illegal, or in contravention of public policy. And the phraseology that my learned friend took objection to, do not strike an appropriate balance and proportionate balance.
So will you tell me those again? They're insufficiently precise, illegal.
Insufficiently certain, illegal, in contravention of public policy, and do not strike an appropriate and proportionate balance between the need to avoid too wide a restraint and the need to provide an effective remedy. The second point is that this is so even when the undertakings are part of a settlement, albeit weight should ordinarily be given to the fact that they are part of the settlement. And the third to fifth points respond to the 4 grounds, the remaining 3 grounds of appeal. Points 1 and 2 are the answer to ground 1. So point 3, which is the answer to ground 2, the judge was not wrong in law to accept the relevant undertakings on the ground that they were too broad or wide. Point 4, which responds to ground 3, the judge was not wrong in law not to accept the relevant undertakings on the grounds that they were too vague. point 5, which responds to ground 4. The judge was not wrong in law. That is, of course, the test. To fail to indicate he would accept the relevant undertakings. If they were subject to an appropriate narrowing of their terms to meet his concerns. If I can start with the legal framework and be as brief as I can, given the points of agreement between us. We're concerned here with a Part 36 offer and acceptance. It's common ground between us that these offers are capable of giving rise to valid agreements, subject to normal contractual principles. Those normal contractual principles are also not in dispute. They include certainty of terms, an absence of illegality, and not being contrary to public policy. We can see from authoritative commentary that these principles apply as much to settlement agreements as to other forms of agreement. If I could just give some references to Foskett. On certainty, Foskett, which is Authorities Bundle 25, paragraphs 349 and 354. And on illegality in public policy, Foskett 471 and 481. I simply want to mention two cases here. We may not need to take them up because your lordships have helpfully indicated that you've read Neville, certainly. But Neville, can I just flag, is as an illustration of an early case. It's Authorities Bundle 1. I don't think we need to turn it out. Where the term in an agreement was held to be invalid as being both in restraint of trade and as contrary to public policy. And these were two separate and independent bases on which the term that the defendants would not publish any comment on the claimant's company in any periodical published by them. These were two independent bases on which the relevant term was unenforceable. The other case I wanted to mention, again, I don't think we need to turn it up, I'll be guided by the bench, is London Regional Transport, which is at Authorities 8. And the reason I mentioned that
yes,
case,
well, I think that is an important authority. I think that might be worth a quick glance. It's unfortunate we don't have the report in the bundle. We do have the judgment, which is adequate.
so this is tab 8. Which was an application for permission to appeal against a decision to discharge an interim injunction, restraining publication of a report that was critical of a proposed project for the London Underground.
And was subject to express contractual agreements as to confidentiality.
Yes. Indeed, my lord. And the first instance judge had regard to the reason the case is of interest is because it considers Article 10 of the European Convention as effectively one of the ways in which one might have traditionally thought of public policy concerns, as now reflected in statute. So it's a sort of modern version, if you like, of Neville. And you see at paragraph 32 that the first instance judge has regard to section 12 of the Human Rights Act in performing the task of
Well,
deciding whether or
That's
not.
actually a reference to Surandry Morit in Imutran, not the first instance judge in this case, but the point remains good.
Yes,
So which paragraph were you on there?
32.
Those two, thank you.
quite right, my lord. And the paragraph 40, we see that the decision is that the public interest required publication. Even if an exceptional case, fourth line down, had to be made out for breaching an express contractual provision as to confidentiality. And the reasoning is then set out in some detail. The appeal is ultimately dismissed, and the key paragraphs are in the judgment of Lord Justice Robert Walker, paragraphs 49 to 50, on page, I think it's 111, 112 on the right-hand side.
I don't have any page numbers, but 49 to 50.
49 to 50. It's 3 pages from the back.
This is the Metwand case, isn't it?
And then the judgment of Lord Justice Sedley, which provides the reasoning in relation to Article 10, paragraphs 53 to 60. 54, equity and the common law are no longer the only relevant sources of law in this field. Goes on to consider Article 10 at paragraph 55. Whether or not, this is halfway down, paragraph 55, undertakings of confidentiality have been signed, both domestic law and Article 10.2 would recognise the propriety of suppressing wanton or self-interested disclosure of confidential information, but both correspondingly recognise the legitimacy of disclosure undertakings, notwithstanding if the public interest in the free flow of information and ideas will be served by it. 56, the reference to the Metwand. 57, discussion of proportionality. As an elastic concept. And then paragraphs 59 and 60, section 6 makes it unlawful for the defendants to act incompatibly with convention rights. They may neither contract out of the act nor use their powers to stifle the convention rights of others.
Yeah. So the upshot of this case was the Court of Appeal endorsed the first instance judge's refusal to enforce an express contractual agreement for confidentiality because public interest in the shape of the freedom to impart and receive information protected by Article 10 trumped the private rights of the parties.
Indeed, and the only other reference was paragraph 61, which is obviously the obligation on the court.
Yeah.
Yes, and this was also a case where the relevant party was a public authority, so that is an extra factor which isn't present in the current case.
That is correct, although of course the obligation still sits with
Well, the court
Court
still
of
has its
Act.
obligation, but the LRT
Yes,
was, it would have been unlawful for LRT to act incompatibly with Article 10.
that's right. So these are general principles applicable to contracts and within them settlement agreements. So of course, although the parties are free to contract as they wish, that will be subject to, when they eventually come before a court, whether on an injunction or in relation to a dispute as under the contract, because the court will at that point have to grapple with whether a proper agreement has been made or whether the terms of the agreement, purported agreement, can be enforced. So briefly, just to touch on some principles applicable to injunctions, because it's common ground between the parties that the approach injunctions can be granted by the court to enforce the terms of the contract, and the enforcement of an injunction in that way is very similar to what follows when an undertaking of the court is breached. And in view of the somewhat sparse case law on the topic that we're here to discuss this morning, some relevant principles can be gleaned from the approach to injunctions. Common ground that the jurisdiction of the court to grant an injunction is discretionary. My learned friend took you to Snell's equity, and this is so in respect of both negative and positive injunctions. There was some suggestion in my learned friend's skeleton that the position was significantly different in respect of negative injunctions. And he took you to the case of D&P. And I wanted just to turn up pre-anchor shipping, which is Authorities 19. And paragraph 91, where at the end of a series of paragraphs which start, I think, at 62, going through the case law on negative covenants and the negative injunctions and the circumstances in which they might not be granted. The principles are summarised at paragraph 91. Negative covenants will ordinarily, although not invariably, be enforced by injunction. Little 3, an injunction is equitable and therefore a discretionary remedy. And then little 4, so far as the exercise of discretion is concerned, there may be cases where the circumstances are such that the grant of an injunction would be unconscionable. And in such circumstances, an injunction should be refused. While a mechanistic approach should not be followed, inconvenience or hardship to the defendant is, however, not enough. So, my learned friend took you to the categories listed in Snell's equity as a sort of complete list of the circumstances in which a negative injunction might not be granted. But in my submission, the test is a broader one. It is essentially one of unconscionability or the justice of the situation. It's an equitable remedy. And although equity has tried to distill into categories the circumstances in which an injunction might not be granted, the categories are not closed, and the litmus test really is the justice of the situation. And one sees that if I could ask you, sorry, I thought I had it in this judgment, if I could ask you to turn back to D&P, which my learned friend took you to at tab 14. My learned friend took you to paragraph 21. Where we see Sir Colin Rymer saying, given an injunction is a discretionary remedy, wary of attempting to prescribe with any sort of particularity the types of circumstances in which it might be appropriate to refuse an injunction. Exceptional circumstances provide a helpful general explanation as to the type of case in which it may be just to do so. So that is the real test. And over the previous page, the remarks of Claimant J that Nicklin J is referring to are at paragraph 18. Talks there about granting an injunction would be so prejudicial to a defendant, causing such hardship that it would be unconscionable for the plaintiff to be given injunctive relief. And so those are the sorts of scenarios in which it may not be just to grant an injunction. So in the context of injunctions, they will not be granted unless they can be granted in terms which are sufficiently clear and unambiguous. That's not in dispute. And then they will also not be granted unless they can be granted in terms which are no wider than the claimant's right, provided an effective remedy. Can I ask you to turn to G, which deals with this in relation to injunctions, which is tab 26. Now we see the first two paragraphs deal with certainty, third paragraph with third parties, and then the fourth paragraph, which begins, there is also the principle that an injunction should not be expressed in wider terms than the claimant's right. There is a recognition in the following paragraph the principle is not absolute and may have to give way to the practical doing of justice. The principle is also more readily applicable to a final injunction, because by then the relevant rights will have become defined. But the position on an interlocutory injunction is then described as somewhat more difficult. The quest for precision and clarity 3 lines down may well come into tension with this principle, and a pragmatic solution may have to be found which will enable the order to work effectively but at the same time not impose too wide a restraint. And then the countervailing principle that the relief granted by the injunction should be effective. And then some examples. And then over the page, the last paragraph. Often not possible to specify in minute detail the scope of the injunction, some leeway is allowed in using generality in the order, but the extent to which this may properly be done is a matter of degree and depends on the circumstances. And then at the last sentence, even with final relief, the width of an injunction is a matter of discretion for the court, which will exercise it according to the particular circumstances and what degree of protection for the claimant is appropriate and proportionate. You see there's some echo of the language that I have used in paragraph 4.1 of my skeleton argument. It is an imprecise task, but what the court is essentially doing is seeking to balance the essential quest, which is to provide some relief in terms that reflect the claimant's right, but balancing against that the need to provide a practical and effective remedy. In the context of what is appropriate and proportionate in the circumstances of any given case. So that does not mean one can never go wider than the claimant's right. And it also does not mean that one should have no regard to the ambit of the claimant's right. It is essentially a balancing test. And I'll show my lords and lady in a moment an Australian case in the context of undertakings, which in my submission is an application of that sort of an approach. Now, in my submission, it's appropriate to consider these matters, certainty and breadth, when deciding whether to grant the injunction, rather than when deciding whether or not to enforce it. It's not an adequate answer to say, well, this can all be dealt with if one is back in court on an enforcement application. When the order is made, the court should ordinarily be willing to enforce it if necessary. And the authority for that is South Buckinghamshire, which is at Authorities tab 9. The relevant paragraph is paragraph 32. The background of the case, House of Lords decision which concerns planning authorities that obtained injunctive relief against gypsies to prevent them from living in mobile homes and caravans on certain land. The defendants appealed on human rights grounds and the Court of Appeal allowed the appeals. The authorities then appealed. And the House of Lords dismissed the appeal. The court would not grant relief just because the authority said it was necessary or expedient to restrain a planning breach, and had regard to all the circumstances it needed to have regard. And at paragraph 32, in the course of Lord Bingham's judgment, he says, when granting an injunction, the court does not contemplate that it will be disobeyed. Apprehension that a party may disobey an order should not deter the court from making an order otherwise appropriate. When making an order, the court should ordinarily be willing to enforce it if necessary. The rule of law is not well served if orders are made and disobeyed with impunity. Now, this paragraph is picked up in one second case that I ought to take you to, which is the case of Meyer, which is at Authorities 13. Now, this is relevant paragraph is passage starts at 79, and it's another planning case. The Secretary of State sought an order for possession and an injunction to restrain travellers from re-entering a site. And the appeal concerned, well, the injunction was refused, and on appeal before the Supreme Court, the injunction that had been granted by the Court of Appeal was maintained despite the limited prospects of enforcing it. And we see discussion of the prospects of enforcement at 79. That brings me to the question, Lord Newberger, whether an injunction restraining travellers from trespassing on other land should be granted in circumstances such as the present. Paragraph 80, as Lord Walker said during argument, the court should not normally make orders which it does not intend or will be unable to enforce. And then discussion about the facts of that case. The defendants presumably have no significant assets. Many of the defendants are vulnerable. Most of them have young children, and imprisonment may well be disproportionate. And then paragraph 81, this is a citation of some lines from the judgment of Lord Bingham in South Buckinghamshire that we were just looking at. Lord Bingham also said, apprehension that a party may disobey an order should not deter the court from making an order otherwise appropriate. The court may consider it unlikely that it will make an order for sequestration or imprisonment if an injunction it was being invited to grant were to be breached, but it may nonetheless properly decide to grant the injunction. So this, in my submission, is not inconsistent with South Buckinghamshire. South Buckinghamshire is authority for the proposition that when an order is made, the court should ordinarily be willing to enforce it if necessary. Ordinarily be willing to enforce it if necessary. And the Meyer case simply indicates that the court may consider it unlikely that it would enforce the injunction if it came to it because of particular factual circumstances of the case. But it can still properly decide to grant it. So there are narrow circumstances in which it might be unlikely that an injunction would be in fact enforced. But the enforcement there relates to the circumstances of the defendant and not to do with the terms of the order. So what Meyer is not a proposition for is that it is appropriate to grant an order in terms which it can be already seen will be difficult to enforce. So if I can turn to undertakings to the court, which have been described as equivalent to an injunction, in my submission, by analogy, they should also not be accepted unless they are sufficiently certain or of appropriate ambit. for the circumstances of the case. On certainty, my learned friend took you to the Wilson case, where we can clearly see that terms that were understood to have been embodied in a request for an undertaking to the court were considered to be insufficiently certain. And the court therefore suggested that the terms simply be agreed between the parties so that no burden was put upon the court. And that is why the Tomlin form of consent order was ultimately settled on in that case. On certainty, there are also references in the Asplin case, the Australian case I mentioned, which is the case I wanted to go to on appropriate ambit. So that is at paragraph 10 of the bundle. You see from the head note, the court's power to accept undertakings subject to the same limitations as the court's power to grant injunctive relief. And undertakings must be in clear and unambiguous terms and not involve an impermissible delegation of power. And then discussion of how the test was applied in the circumstances of that case. Now, this was a competition case where agreement had been reached to settle the proceedings. Paragraph 2, there were no admissions, but 5 undertakings were proffered by way of settlement, and the court was asked to accept them. They are set out at paragraphs 3 to 6. Details of who gave them. Now, at paragraph 25, we see the beginning of the discussion of principle. And the statement that I read from the head note about an undertaking, the power to accept an undertaking being subject to the same limitations as the power to grant an injunction. Citation of Australian authority. And then discussion of the basis for the similarities at paragraph 26. Undertaking to the court is given in lieu of an injunction, remedies are the same. And then a citation from the Thompson case, which makes good that point. Now, this was a case in which the power to grant an injunction was contained in statute, and so it is not immediately on all fours with this case. But I do say that there are points of principle which are still of relevant application. Paragraph 29. In the same way as an injunction must be couched in clear and unambiguous language, so must an undertaking. And then paragraph 30, there must be a relevant nexus between the injunction or undertaking and the alleged or established contravening conduct. Now, in my submission, that proposition is a reflection of the language that one saw in G, talking about the need to provide a balance between the provision of an effective remedy and to avoid too wide a restraint. We see that the application of that principle, as well as the principle on certainty, to the undertakings which the court in this case refused to accept. So that's paragraph 'We pick it up at paragraph 45. The undertakings that have been dealt with up to that point have been accepted if the court doesn't take issue with them. And then paragraph 45, an undertaking, third undertaking is set out there. implementation of recommendations in a report. The bottom of paragraph 48, it seems to me that there are two difficulties with this undertaking. First difficulty is that the compliance programme to which the undertaking relates goes beyond the provisions of the relevant act. The second difficulty relates to the nature of the recommendations. Is it within power or appropriate to impose nothing more than an obligation to consider doing something? And then at the bottom of page, paragraph 49, the difficulty with some of the recommendations set out above, they do not even place an obligation on or spin to consider taking a particular course of action. So, too vague, insufficiently certain. And then the fourth undertaking, to implement a trade practices corporate compliance programme. The terms of the programme are set out. We see at paragraph 52 over the page. The principal problem is that major aspects of the programme are not defined. Formulation of the programme is left to the respondent and the external consultant. And a further difficulty is that there is a suggestion that the programme may be changed from time to time. So, again, insufficiently certain. So, although this was a case in which the nexus was provided by the terms of a statute, the principle that there should be sufficient nexus between the terms of an undertaking and the impugned conduct, in my submission reflects the comments that we've seen in G and is of more general application. If I can move on to consent orders very quickly, it's simply to address, sorry, my learned friend took you to Arledge, citing the case of Harris. This is now, before I go to Arledge, Mr. Justice Nicklin gives some acknowledgement of the need for there to be some sort of a nexus when he says at the end of paragraph 19 of the judgment, for example, in some cases, the undertakings that are agreed may be a reflection of the relative bargaining power between the parties, such that one party is arguably able to extract whatever terms she wants as a price of the settlement from the other. Now, one can phrase that in various ways. That a sort of an extraction of that kind might be reflected in terms which are contrary to public policy. It might be reflected in terms which don't show sufficient nexus to the relevant conduct in the case. There are many ways in which that could be manifested. But in my submission, one of the things that Mr. Justice Nicklin had in mind there is this need for there to be some link between the bargain and the underlying subject matter of the proceedings. If I can just quickly deal with the Harris case, which my learned friend took you to, that is a case at tab 7 of the bundle. Which my learned friend took you to Arledge, because that is the case cited at the end of paragraph 12.204 of Arledge in support of the point that the court is not confined to accepting undertakings in terms which it would have the power to impose without consent by way of an injunction. But if one actually looks at that case, it's about something quite specific. So tab 7 of the bundle, and it's a case which was about undertakings which could properly be extracted from contemners who wish to obtain their discharge from prison. and not a case about undertakings from those who are not yet committed. Paragraph 10 is the relevant passage. Mr. Justice Mumby says, any contemner is entitled to apply at any time to purge his contempt. Well established, the court can and frequently does grant fresh injunctions or accept further undertakings from the contemner when discharging him from prison. It may be noted that so long as the undertaking is expressed in sufficiently clear language, as itself to be capable of founding a future committal in the event of breach, there is in principle no limit to the terms of the undertakings that can properly be extracted from a contemner who wishes to obtain his discharge from prison. So in my submission, the point that is made there is very clearly confined to the circumstances of a contemner who wishes to obtain his discharge from prison, and it's not, the case is not authority for a more general principle, such as would be applicable to the facts of this case. On consent orders, very briefly, one comment on the Bruce case, which is that the list of categories there, insufficiently certain, illegal or immoral, where the court can decline to give effect to a consent order, is not a closed list. And my Lord Justice Warby was correct to point out that it's not the ratio of the case, and in fact, if one reads the case, it's in fact about the jurisdiction.
That's the rent tax and,
Yes.
and a specific jurisdiction.
So it's helpful, but it's not authority for a limited list of circumstances. And it's also in my submission not a list that one can equate with exceptional circumstances, which is where my learned friend arrives in his skeleton argument. He says, at paragraph 22, citing from Mionis, that the language that Lady Justice Sharp uses there about upholding a bargain, save in exceptional circumstances, includes three matters listed by Stoughton, Lord Justice Stoughton, in Bruce. In my submission, there isn't warrant for a test of exceptional circumstances. The test is, are any of the limiting principles that I've identified present? And to impose a test of exceptional circumstances is to impose an unwarranted gloss. Of course, it is right that weight be given to a settlement agreement, but that doesn't necessarily mean that it will only be in exceptional circumstances that a consent order giving effect to a settlement agreement will be upheld. One has to apply the relevant principles. So if I can then just canter through the grounds, having done most of the work with the groundwork on ground one, as a point of principle, the submission is the judge was not wrong to refuse to accept proper and enforceable undertakings. He formed the view that undertakings 1 to 3 were not proper and or enforceable for the reasons which are impugned under grounds 2 and 3. There is, in any event, no test of exceptional circumstances, as is posited by the appellant. The questions are those of sufficient certainty and appropriate ambit. The appellant sets great store by the Mionis case. 2 points about the Mionis case. The first is that the passage my learned friend cites in Mionis is a citation of Warren. So my learned friend cites paragraph 87 of Mionis. If we could just quickly turn that up. Now, Mionis was a case case where it had been an issue that the clause was too vague or uncertain, but this was then, the defendants then conceded that the clause was not too vague or uncertain before the matter came before the Court of Appeal. They also admitted that they were in breach, but contended that enforcement would be a disproportionate interference with Article 10, and hence the discussion of Article 10. Lady Justice Sharp accepted in principle that a court might conclude that a bargain was disproportionate and refused to enforce it on grounds that it violated Article 10. One sees that at paragraph 67. By D, the court has a duty as a public authority to refrain from acting in a way that is incompatible with convention rights. And then at F, where the relevant contract is one of settlement of litigation, sorry, the point of principle is before that, between E and F. And then at F, saying that it would require a strong case for the court to conclude that the bargain was disproportionate and refuse to enforce it. But it follows that it is an option which is available to the court. And then Lady Justice Sharp considers the Warren case from paragraph 78. And the Warren case is important because it's the case that Lady Justice Sharp is referring to in paragraph 87, where she refers to exceptional circumstances. And the Warren case is different. The Warren case concerned an offer of amends, not an agreement not to repeat the words complained of. And one can see that at paragraph 79. And one can also see at paragraph 84, Lady Justice Sharp noting that the court held there was no interference with the defendant's Article 10 rights in the Warren case because the offer of amends and its acceptance did not prevent the defendant from repeating the words complained of. So, Lady Justice Sharp considered at paragraph 86 that the issue that arises in this case, the Mionis case, did not arise for decision in Warren's case. And the court made it clear, did not need to consider how the Human Rights Act affected the enforceability of contracts in light of the conclusion that the offer of amends regime was compatible with Article 10. The observations in the Warren's case on the court's role where there was a contract of settlement were therefore strictly obiter, the last sentence of paragraph 86. So, we do say that the Warren case is not authority for the point that is made, and that the exceptional circumstances test is not one that is made out. The clause in the Mionis case was upheld because it wasn't in dispute that the meaning of the terms on which the parties had contracted was objectively clear. You can see that at paragraph 93. The court formed the view that the difficulty of enforcement had been considerably overstated, paragraph 105. And there were no grounds for reviewing the fairness of the terms, paragraph 96. So this is not in fact inconsistent with the approach in cases like Wilson and Asplin, the case that the court can refuse to accept undertakings which are either too uncertain or which are too broad. The parties can settle on terms wider than the precise ambit of the claimant's right, but the breadth of the settlement has to be appropriate and proportionate to the fact given the circumstances of the case. In this case, the parties' Part 36 agreement was made on the basis that there agreement would be upheld by the court because it was conditional on the court accepting the undertakings offered. And that's relevant to ground 4, which I'll deal with just before I deal very quickly with the submissions on undertakings 1, 2 and 3. I have one point in relation to each undertaking. So ground 2, the judge was not wrong to find that the relevant undertakings were too broad or wide. The appellant says that the judge's objection was in truth to breadth and not vagueness, which is a separate concept. But of course, vagueness can lead to excessive breadth, and so the two are in fact linked, although separate. The appellant takes us to 3 other cases by way of example of the courts being familiar and happy to grant these sorts of undertakings. Other cases in my submission are of limited relevance because the appropriateness of the ambit of a term depends so much on the factual context of the relevant case. If one looks at due, without turning it up, it's tab 22, we'll come to it in a moment. We don't have the full facts of the case, we don't have the full terms of the undertakings. Similarly with Galloway, tab 18, we don't have the full facts of the case, we don't have the full set of undertakings, we don't have details of the breach. In those circumstances, it's very hard to draw anything reliable from the court's decision to commit. And so those cases ought to be treated with caution. Bearing that in mind, dealing with each of the undertakings, undertaking 1, which was the undertaking about publication by any means, express or implied reference to or any pictorial depiction of the claimant. It's of relevance that insofar as one can make any comparison with Galloway, that undertaking here is wider. So Galloway did not include a pictorial depiction. Also, to the extent that that is of relevance, you have, I think, the points that the judge made about preventing statements of apology and other legitimate non-disparaging references with insufficient nexus to the impugned conduct, and my Lord Arnold has given a very powerful example of one such reference that would be precluded by that clause. My learned friend says that the clause in Mionis was upheld, but the clause in Mionis was of a narrower format as well. It was also expressly conceded by the defendant that it was sufficiently clear, and there was no freestanding issue as to breadth. Undertaking 2, the judge was entitled to take the view that it caught all forms of impersonation and was not limited to online impersonation, which was where the nexus to the impugned conduct lay. And in my submission, that undertaking is a very good example of why the nexus to the conduct is important, because there was no complaint in the particulars of claim as to impersonation. And it's therefore a good example of the need for caution in making sure that terms are not drawn too widely, and indeed so widely that they bear no resemblance to the actual conduct.
Well, impersonation is impersonation, whether it's done online or in person. It's not exactly one of the top end of Article 10 rights to go and impersonate someone else.
But it doesn't need to be, well, impersonation can be online and impersonation can be in person. Now, impersonation in person would capture a stand-up comic, or mimicry as it's been described. And there are, one might legitimately say that actually that sort of thing in the confines of one's own house with friends is the sort of thing that ought not to be chilled, because it's very different to setting up a profile on an online account, posing as an individual and offering services. Now, although the U case involved an undertaking addressing impersonation, my learned friend took you to paragraph 3, we have a paraphrase of the undertaking. We don't have its full terms, and it's also not clear whether that particular term was breached and whether that was part of what was considered on the committal application. In terms of undertaking 3, the reference here was to seeking to monitor the claimant's activities, including but not limited to her activities on the World Wide Web, social media, or the activities of her friends and family. But the word activities would capture all activities, not just online activities. And that contrasts with the position in the Belfield case, where the terms of the order were narrower. I'll just turn that up quickly. It's tab 23, and it's paragraph 61 that you were taken to. There, the language was to monitor the use by them of the internet, email, or any other form of electronic communication. So that makes it clear that it's about monitoring online activities and not real-world, day-to-day activities, walking down the street and so on. Now, you may say it's necessary for the relief here to be drawn wider, but of course, again, the circumstances of the case and the conduct that it was concerned with was online monitoring.
But that wasn't the judge's complaint about it. He said monitoring is wide enough to cover an internet search.
Indeed, I mean, that's a further objection, my lady, but in my submission there is a prior objection, which is even broader than that on its face. So, for those reasons, there was no error of law in finding that the relevant undertakings were too broad and wide, and/or wide. And as to vagueness, the same points arise in the following way. The first undertaking was insufficiently precise about whether certain types of reference were caught, be that legitimate references like citations in publications or apologies made to the world, not through a solicitor. The second undertaking was insufficiently precise about the type of impersonation caught. And the third undertaking was insufficiently precise about the type of activities caught. Complaint is made that undertaking 7 was accepted. This is not directly relevant to the question of whether there was an error of law in finding that undertakings 1 to 3 were too vague. That should stand and fall on its own. But undertaking 7 was accepted because the term harassment reflected the language of the Act, and the nexus with the impugned conduct was provided by the fact that the claim was brought under the Act and particularised the activities said to amount to harassment. And that list of activities wouldn't have included in-person impersonation or the monitoring of someone walking down the street as an activity. So, for those reasons, there was no error of law in finding that the undertakings were too vague. On the last point, it's alleged that the judge was wrong in law in failing to invite a narrowing of the undertakings. The appellant says that undertakings 1 to 3 continue to have contractual effect. Even if that is right, which I'll come back to in a moment, while the judge could have indicated that he would accept those undertakings if they were subject to an appropriate narrowing of their terms to meet his concerns, he was not obliged as a matter of law to so indicate. He made no finding that he had no jurisdiction to take such a course. That is the sort of finding that might have given rise to a good claim that there had been an error of law. But he didn't make such a finding, so he didn't err in law in failing to make any such indication. In any event, the appellant could have offered narrower terms of her own volition, either at the same hearing or subsequently. But there is reason to doubt that undertakings 1 to 3 necessarily continued to have contractual effect. It is, I think, relevant to consider whether, in fact, the appellant's Part 36 offer contained an implied condition precedent that the undertakings offered by the defendant would be accepted by the court. There's one final authority to go to.
But that wasn't the basis on which the judge dealt with it. He assumed that there was a contract, didn't he?
He did. No, I mean, I make this point, and my lady, simply to put all the points before the court.
Mhm.
My lady's quite right. But that is the way that it was dealt with. In the Smallman case, at tab 2, at paragraph 31, Lord Denning states, in my opinion, if the parties have reached an agreement on all essential matters, then the clause subject to the approval of the court does not mean there is no agreement at all. There is an agreement, but the operation of it is suspended until the court approves it. It's the duty of one party or the other to bring the agreement before the court for approval. If the court approves, it is binding on the parties. If the court does not approve, it is not binding. But pending the application to the court, it remains a binding agreement which neither party can disavow. So in my submission, that is about the approval of the court in general terms. But there's no reason of principle why that logic should not also apply to the acceptance of undertakings by the court. And if that's right, then an agreement which contains as a constituent part undertakings which are dependent on the approval, the acceptance of those undertakings by the court, is a conditional agreement that comes into force if the court accepts those undertakings.
And if the court doesn't,
The logic,
there's no settlement agreement.
well,
There's
the
no
logic of it is that effectively the parties can either resile from the agreement on the basis that it doesn't reflect their bargain, or they can affirm it. I think that would be the logic, as the court has accepted 5 of the undertakings, but not the other 5. But the parties are still content. The order would then still be sealed, and there would still be an agreement. But arguably, the parties could have indicated that their agreement no longer stood in light of the court's decision to refuse the relevant undertakings, because it was part of the agreement that the undertakings to the court were anticipated to be accepted. So it would follow from that the parties could have asked the court not to approve the terms of the consent order, or to seal the final order, so that they could reconsider the terms of their settlement, including perhaps considering the precise terms of the undertakings with which the judge had concerns. because otherwise one has a difficulty, which is that the parties have entered into a bargain in anticipation that the court will accept certain undertakings. That's the nature of their agreement. The nature of their agreement is that they are willing to dispose of the matter on the basis that all undertakings are accepted by the court. So I offer that as a alternative solution that might have been available. But for those reasons, we say that the judge below wasn't wrong. And unless there are any more questions for me, I should sit down.
Thank you very much indeed, Mr. Tomlinson.
Subject to any questions that the court has, I just wanted to make really 2 points. The first concerns the last of the points made by my friend. If the court takes up a bundle which hasn't yet attracted the comment, supplemental bundle, one finds at tab 7 the Part 36 offer which was accepted. And ingenious though my friend's point might be in relation to conditional settlements and so on, it plainly has no application, because if you turn to page 29, what the claimant agrees to accept is the provision of a signed undertaking to the court from the defendant in those terms, and such a document was provided. It doesn't actually say that the court has to approve it. So there was a binding contract. There's no condition precedent to its taking effect. Just for the courts, in case the court hasn't focused on it, can I just refer to tab 8, page 34, which are that's the offer that was made by the defendant, and one sees that the same, effectively the same undertakings were offered by the defendant subsequent to the defendant's acceptance of the claimant's Part 36 offer. So this is not, on the face of the document, something that imposed out of the blue in terrorem by the claimant. The only other point I'd make is that if the court were minded to take the interesting course proposed, I think it's fair to say jointly by our Lord Justice Warby and Lord Justice Arnold, to narrow the undertaking 1 without the agreement of the parties, the court may wish to consider wording to this effect: upon the court declaring that undertaking 1 shall not be enforced where the alleged publication is a reference to the claimant in a scientific or academic publication. I'm not suggesting the precise wording, but something along those lines would perhaps meet the concerns that Lord Justice Arnold so clearly articulated. I wasn't proposing to say anything about the authorities referred to by my friend, unless there's anything that the court thinks would assist.
Thank you. Thank you very much indeed. And thank you to you both, and thank you particularly also to Ms. Patel for assisting the court today. We're very grateful to both of you, and to Mr. Hamer also, and those behind you. We will reserve our judgments. They will be dealt with in the usual way, which you will be very familiar with. Drafts will be sent out, and we would like comment in the sense of typographical errors, but not in the sense of re-argument, thank you. But we also should draw your attention to the embargo, which is taken extremely seriously. You've provided the email addresses of those within the circle to whom the draft should be circulated. Please take care to remain within that circle. Also, as you'll all be very well aware and know, all consequential matters in this court we hope are to be agreed, and if they are not, very short written submissions should be made, and they will be dealt with on paper. As I say, we're very grateful to both of you. Thank you.
All right, exactly.
Thank you.